case number AP 77088, Gary David Greene versus the State of Texas.
Good morning, Your Honors, and may it please the Court. My name is Thea Posel, and along with Raoul Schonemann, we represent the appellant Gary David Greene in this case. This is an appeal from a conviction and death sentence out of NUECES County on change of venue from Upton County in West Texas. This morning, I will first discuss the issues related to the state's improper closing argument at penalty. Then I'd like to discuss the denial of the requested lesser-included offense instruction, and I've reserved 3 minutes of my time for rebuttal. At penalty argument in this case, the state displayed a PowerPoint slide with data on it and told the jury that, I quote, "It's been 2,094 days since October 2nd of 2013. 31 Texas officers have died from gunfire. I segregated it out only for gunfire from 2013 till today. That's 10% of the nation's officers, 309 that have died." At which point, trial counsel objected, said that this was improper argument, there was no evidence of this in the record, it had nothing to do with Mr. Greene or the case at bar, and it was improper under the 8th Amendment as well.
Counsel, would it have made a difference then if instead of no PowerPoint, he just said how many officers have died in the line of duty from shooting this year alone? Wouldn't that be a proper plea for law enforcement? Why is it the extra stuff make it more prejudicial?
Well, Your Honor, this court has said that the injection of extra record evidence into closing argument is improper per se. There are 4 permissible bounds of argument at summation, including summation, reasonable deduction from the evidence, answer to an argument of opposing counsel, or a plea for effective law enforcement, but that does not include additional facts that are not in the record. So this court has before reversed cases in death penalty and non-death penalty cases. We cite the case of Lopez versus State in our briefing where the prosecutor made a comment.
Just mentioning that other officers have died from shootings, isn't that injecting evidence in the record?
Well, I would agree, Your Honor, and instead here the state went further. They researched, compiled, segregated, and presented these facts that were not in the record and urged the state by emphasizing this, or urged the jury throughout to return a verdict based on this improper evidence. So immediately after the objection was overruled, the state continued, spoke about the decedent Deputy Kennedy in this case, but then talked about law enforcement families more broadly, about their experiences and their joy and their pain when they lost their own loved ones. Then the state invoked the patron saint of law enforcement, St. Michael, pulled a coin of the saint from their pocket and showed it to the jury, saying, "I've carried this with me throughout trial. I pass it on to you. Life without parole is insufficient for Gary David Greene. Don't let them down." And later, in rebuttal closing, another prosecutor invoked the slide from before, said, you know, there's one victim in this murder, in this case, but as Laurie showed you in the PowerPoint, there are so many more. And then finally came to emphasize kind of misrepresenting the testimony of a defense witness to tell the jury that people who are convicted of killing a law enforcement officer do not get life without parole. So the state has already conceded that this argument was improper. The question for this court now is whether there was harm. And under both state law and federal law, there was. So when this court examines issues of extra record facts injected into closing argument.
What was the total percentage of time spent on this? I mean, there was a whole lot more to closing argument than just this.
Yes, Your Honor, and the state points out that it was a certain amount of lines in the transcript, but when this court assesses the severity of the misconduct and the prejudicial effect, it asks whether the argument was emphasized, not whether it was just repeated. And so the kind of return throughout this thematic use of other law enforcement deaths and what other law enforcement, other defendants convicted of killing law enforcement officers get, emphasize this improper argument. So one of the other factors that this court looks to are any curative measures that were taken. In this case, the trial court overruled the objection. They issued no admonishment to the jury like we often see, you know, the arguments of counsel are not evidence, did not admonish the prosecutor for the argument. And so that potentially indicated to the jury that not only was this not objectionable, but it was a proper consideration when assessing the penalty for this defendant in this case. And finally, this court considers the certainty of the conviction or penalty absent the misconduct. And here, there were a number of reasons why the state points to in their brief the verdict could be sustained, but the sufficiency of the evidence is not the question.
A question. Is it inappropriate to talk about the impact of this type of a killing on society so that if a jury, for example, wants to send a certain message, right? If you say, this is really bad conduct, and we want to ensure that people know that if you get found guilty of this, that you're going to be punished severely, is it not appropriate to, and I'm not suggesting it is, I'm just asking your opinion about it, is it not appropriate to emphasize that this is happening a lot? Is that not proper?
Well, Your Honor, in Freeman versus State, the prosecution made a statement that the defendant had attempted to commit one of the worst acts against law enforcement in history. That was found to be improper, even though it was not a specific injection of evidence. This court has, in some cases, said that sending a message to a community is a proper request, but the specific evidence introduced here and the request for a verdict based on that, as well as the suggestion to the jury that people who are convicted of killing a law enforcement officer don't get life without parole, pled the jury not to let the other families of other law enforcement victims down by sentencing this defendant, in this case, to death, I think took it beyond not only a state law issue, but it infringed on appellant's right to an individualized determination of sentence under the Eighth Amendment based on the circumstances of this offense, his characteristics, his background. I think this court has also, in non-death penalty cases, found improper injection of additional data in response.
Excuse me, just
Yes,
a
Your
moment,
Honor.
please. Would we have visitors in the back that don't have a seat? Would some of the court staff give them their seats, please? Thank you. You can stand in the back.
Well, let me ask this. You mentioned the line, people don't get life without parole for killing a police officer. I mean, are you characterizing that line as no one else who's done this crime has gotten life without parole, or is there a chance that with the meaning of that statement is a normative statement, like you should not get life without parole for killing a police officer? Like,
Thank you for that question, Your Honor. The reference that I'm specifically pointing to was in the prosecutor's summation of the defense risk assessment expert's testimony, and he was asked on cross-examination about, certain studies, and then what he actually said during his testimony was that 2 of the studies had an insufficient sample size. He said one of the reasons for that was based on the way that the federal death penalty statute was written, and then the other sample was conducted just from a body of people who had been sentenced to death and were then resentenced to life, and in that specific sample size, there were not enough people who had been convicted of killing a law enforcement officer to make a statistical prediction. So it misrepresented the testimony and told the jury that, what did their expert tell you? He told you there's an insufficient sample size. What does that mean? That means that people who kill law enforcement officers do not get life without parole. So I think in terms of the question you pose, it is much more the former. In terms of the constitutional issue, the questions before this court are whether the clearly erroneous ruling that allowed the state to introduce this extra record evidence and argue from it, entirely unrelated to appellant in this case, and argue that he should be sentenced to death based on that, did violate his Eighth Amendment right to an individualized determination of sentence. And then whether that erroneous ruling and argument can withstand not only the heightened scrutiny that the Eighth Amendment requires, but the heightened review that this court applies to constitutional error and is required by Chapman versus California. The answer to the first question is yes, and the answer to the second question is no. Reversal is required. The state, in their brief, recites the evidence that is sufficient to support the verdict. And they say that they believe that the jury could have returned this verdict nonetheless, but that is not the standard. When we're assessing constitutional harm, it is the state's burden to prove the error harmless beyond a reasonable doubt. And given the pervasiveness of this theme throughout their closing argument, they cannot do that here. I'd like to turn to the denial of the lesser included offense.
Just before you go,
Sure.
one more thing was, when the objection was raised, was the Eighth Amendment invoked? in
Yes, it was,
particular?
Your Honor.
Thank you.
So, at the charge conference, the defense requested lesser included offense instructions. One of those were for the offense of murder. The trial court completely denied a lesser included offense at all, which creates both a Beck problem and an issue under state law.
Well, why isn't this just simply an analysis for whether the lesser included instruction was warranted? I mean, I don't see Beck as being, which is a categorical rule that says you can't completely foreclose a lesser included. But if the evidence doesn't raise a lesser included, and if the trial judge doesn't think the evidence raises a lesser included, then how do we even get to Beck if that's what we're dealing with?
Well, certainly, Your Honor, it's a two-step inquiry. So the first question is whether there was some evidence in the record, anything more than a scintilla.
What is your evidence? What is your scintilla of evidence on this issue?
Well, yes, Your Honor. So this court has said when you're looking at what is a scintilla, it is anything more than nothing. It does not have to be strong. This court does not have to find it credible. It does not have to be it does not have to be corroborated or uncontradicted.
I understand that.
So
But what evidence are you relying on to support that proposition?
Sure. Well, as the state has introduced, I believe, bench exhibits before this court, so you have been able to see that the law enforcement officers were dressed in what were called non-standard uniforms. They were not dressed the same. They did not arrive on the scene at the same time. The testimony of Deputy Stiles, who presented evidence at trial, said that Appellant was asleep when he approached the vehicle. There was testimony from both of the convenience store workers that the Appellant seemed to be having a bad day, was not quite making sense. There was a lay witness who approached the vehicle and was looking to buy a truck of that kind. So he was kind of walking around. He noticed the odd behavior of the occupant. He tried to get his attention. He wasn't responding. So when someone is charged with capital murder for killing a law enforcement officer, the state is required to prove not only that that person was a law enforcement officer, but that the defendant subjectively knew that. And there is evidence in the record from which a jury could rationally find that he was not sure.
What is that evidence?
Well, so we know that his state of mind was questionable. So a jury could find that he was not with it at that time. And based on the fact that he did not know what was happening in West Texas, he was not from there. There's evidence in the record that he was from Fort Worth. And the state made sure in their case, because this venue was changed here, they made sure to elicit testimony from the sheriff that this is the way we did it in West Texas, to be clear to the jury that these people were law enforcement officers. That evidence was not available to Mr. Greene at the time.
So someone asked for identification and, whether he was just awakened or whatever, that doesn't, indicate that perhaps this is a little odd, that just somebody from outer space or whatever is asking for ID, and then the second officer has a flashlight and looking at the VIN, and I think the record indicates that they both had something on their apparel that indicated they were law enforcement. So he's asleep throughout this whole thing and doesn't see any of these indications that they're law enforcement?
I believe Deputy Stiles' testimony was that he woke him up. But so he handed the license to Deputy Stiles. That's evidence from which a jury could rationally find that Deputy Stiles was known to be a law enforcement officer to Mr. Greene, but no other evidence exists to impute that knowledge to Deputy Kennedy. And is there evidence sufficient for the jury to convict him? There is, but we're not challenging the sufficiency of the evidence here, and this court has found that denial of lesser included offense instructions in death penalty cases is erroneous, overturn the sentence and verdict, even where they have simultaneously rejected sufficiency of the evidence challenges. So the question is just whether there was a scintilla of evidence, and it may be weak and it may be incredible to this court, but if it exists in the record, a lesser included offense instruction is required.
So your scintilla of evidence is that he was asleep?
Well, he was asleep, and there is evidence that his state of mind was confused. And this court has said the bottom, we don't really know what a scintilla is defined, but we know that it has to be something more than just disbelieving the state's evidence. And here, there is more than that. And so under state law, this court has imputed the rationale of Beck and reversed even where an additional lesser included offense was granted to the jury, even if the particular one requested by the defendant was also raised by the evidence and was not issued by the trial court.
So counsel, again, explain to me more why it is we even get to Beck instead of, if we think the evidence doesn't support a lesser included, it doesn't seem like Beck is implicated at all.
Well, certainly your honors would have to first determine that the ruling of the trial court was erroneous, and we believe there's evidence in the record from which you could so find. As I responded to Judge Hervey, there was evidence that his state of mind was not...
Right, but assuming we don't agree with that and we think that there isn't any evidence to support the lesser included, why is Beck important? Does it provide any extra emphasis for why he's entitled to a lesser included instruction beyond the analysis we would ordinarily do?
Well, in a death penalty case, Beck is specifically concerned with a jury being put to what it called an impermissible all or nothing choice to convict or acquit, particularly where the evidence is strong on most of the elements,
Right.
but there's a question as to why.
So you're saying that Beck requires a lesser included instruction even if it's not warranted?
Where warranted by the evidence
Okay,
and
well,
under
that's
state law.
exactly my point. Thank you.
However, I do believe that this court and the Fifth Circuit have noted that this error can never be harmless. And while this court's assessment of some harm under Almanza is close to that, we believe that Beck speaks specifically to capital cases. And so because evidence in the record could lead a jury to rationally doubt whether Mr. Greene knew that Deputy Kennedy was a law enforcement officer, the lesser included offense instruction was warranted. And I would like to briefly point out this state has raised Williams in defense, saying that the evidence was, or the request was not properly preserved. But in that case, the judge specifically asked the defense counsel to point to evidence in the record. The defendant had testified in his own defense that he committed no offense at all. So the evidence that might support the lesser included was not apparent to the trial judge. The defense counsel did not provide it upon request. And this court in Williams noted that the lesser included offense is warranted whenever the evidence is pointed to in the record or it is manifest. And so because here there was a question about whether Appellant actually possessed the requisite subjective knowledge, there was no statement on his behalf. He was taken immediately to the hospital for surgery following the gunfight with Deputy Kennedy and Stiles. And so there's nothing in the record that goes to show that he knew or that he didn't know, but there is evidence that could lead a jury to doubt. And for those reasons, Your Honor, unless there are any other questions, I would cede the remainder of my time for my rebuttal.
Thank you, counsel.
Good morning. May it please the court. My name is Laurie English. I'm the 112th District Attorney out in Crockett, Reagan, Pecos, Sutton, and Upton counties. Good morning. So I want to speak to the points of error 6 and 7 that Thea started with. I conceded in my brief, I concede before you today that the argument about the officers who had died was improper. Follow my sword, it is what it is. It was improper. I do not believe that it was harmful. I think it was harmless under both standards for review. There's no constitutional error. The severity and the prejudicial effect of that misconduct, and although there were no curative measures made, I know there's the things that you look at to determine the severity of that mistake or misconduct, and the certainty of the conviction.
Did the judge give any kind of limiting instruction or additional instruction regarding that argument?
She did not. Okay, she did not.
Actually, well, was there at least a general instruction in the jury charge that says you're only supposed to make your decision based on the evidence presented?
I believe it was in the guilt innocence charge. I don't remember that it was in the punishment charge.
Fair enough.
The certainty of the conviction, absent the misconduct, is what I want to focus you on today. The appellant had quite a criminal history. The evidence was very overwhelming for the jury from the standpoint of he beat his mother and put her in the hospital and actually ended up serving time for that assault. He beat his ex-wife. He beat his son, and there are pictures in the bench exhibit for you. I'm sorry, not of those things, they're in the trial exhibits, I apologize. The bench exhibits deal with the lesser included part. The son had 6-inch whelps across his back. He was a teenager when this happened. And the slide that Ms. Posel keeps talking about, that the second prosecutor referred to, that slide was actually a photo collage of all the victims that had been harmed by the appellant through the course of his criminal career. His criminal career started when he was 18 with a public intoxication and exposing himself to girls in high school all the way to the day that we ended up with
And
this
why did we
happening.
even need the slide? Why did you even need to put the slide with all the details about law enforcement if you had all this compelling evidence suggesting death was important?
A bad judgment call on my part. So,
Is the, what you just described?
Yes, ma'am.
Is that in the record?
it is not. The defense didn't ask for it. I didn't think to put it into the record. We used it to summarize all the things that they had seen through the course of the punishment trial. So,
Excuse me, when you said earlier that there was no constitutional error, I asked defense counsel if the Eighth Amendment was invoked. Can you explain to me how you think it is not a constitutional violation under the Eighth Amendment? Can you address that for me?
Yes. So I believe it's harmless under the constitutional, under the Constitution as well. The test for that is whether there was a reasonable possibility that it might have contributed to the jury's decision because of the overwhelming amount of evidence.
So are you saying that, I'm trying to figure out if you're saying that it is an Eighth Amendment violation, but it's harmless under the constitutional standard? Or are you saying it's not an Eighth Amendment constitutional violation?
That's a tough question. I know it's improper.
Okay.
Whether it's a violation of the Eighth Amendment, I don't think so. But
That's what I'm trying to, because in order to decide which harm standard
Sure.
which glass we look
Exactly.
through, we have to decide, does it violate the Constitution?
so my answer would be no.
Okay.
It does not. Whether the slide and the comments contributed to the jury's decision, again, we had the overwhelming amount of evidence. The question was raised a few moments ago, and I'm sorry I didn't make a note of which judge asked. The degree of, or the amount of the conversation. I put in my brief, it was very small. It was 4 lines of the transcript, 4 lines on 15 pages worth of closing argument. And so it was very small. As soon as the objection was made, we moved on and we did not address it again. All of the arguments made by myself after that point and by my co-counsel specifically focused on a plea for law enforcement and not other dead officers.
How long did the slides stay up?
A minute, maybe? I speak pretty quickly, as you can tell, and so I was pushing through because I was trying to make sure we got all of our time done.
Counsel, I assume in voir dire there were questions to the prospective jurors about their thoughts on law enforcement, relationship to law enforcement. Is there anything there that you could point to that perhaps demonstrated that this would not have had such a great impact on the jurors that were selected?
Not that I can speak to, I'm sorry, that was a long, many, many days of individual voir dire, so I can't think of anything specific that I can offer, I'm sorry.
Okay, that's all right,
So
thank you.
you do have the transcript, but I don't have that answer for you.
Thank you.
So what the courts tell us and what you all have told us is that you are going to evaluate this, the entire record in a neutral manner and not just in a light of favorable to the prosecution, and we fully expect that. Again, it was a stupid mistake, regrettable from the moment it happened all the way to standing here today. It was not the thing to do. But I still believe that it was harmless under both standards, non-constitutional and constitutional. Are there other questions about that point that I could answer for you? Okay. Moving on to the lesser included points of error 1 and 2, I did file the bench exhibits on Monday for you. Yes, we spent a lot of time during our presentation of to the jury of the evidence, making sure that a Nueces County jury understood the mindset and the protocols and the culture of a West Texas Deputy Sheriff's Office. They don't dress the same way that people do in Nueces County. We moved this case all the way from Upton County to Nueces County, and we were concerned that the jury might not see things the way that would be fair to us from the standpoint of their officers are all in uniforms. They have their expectations would be different than West Texas.
Sorry, doesn't that sort of feed into the argument the defense is making? Like, if you had to educate the jury so much about why these people should be regarded as law enforcement, doesn't make it seem more reasonable that maybe it's easy for someone not to know that the guy was law enforcement or the victim was law enforcement?
The appellant was from a small town also. And it wasn't a West Texas town, but he had been in West Texas before. So I would disagree with that characterization.
Okay.
That we were concerned that the big city folks wouldn't understand the small town mentality.
And isn't the real question whether they had enough on them to demonstrate that they were actually law enforcement?
Yes, and if you'll look at the exhibits, Deputy Kennedy had on a shirt that had an embroidered badge. He had on his duty belt that was obvious, and I gave you 3 pictures that show him walking into the store. These are the store video pictures, stills. He had the badge on his cap said sheriff in big bold letters, and the back of his belt had his handcuffs and all of that. So it was very obvious. The vehicles that they pulled up in also were marked on every side. I gave you a view of every side of his vehicle. And Deputy Stiles had on a cowboy hat, which is a little more common for West Texas than the sheriff's cap, but the sheriff's cap did clearly identify Deputy Kennedy as a sheriff deputy. And Deputy Stiles had his radio strapped across him with the mic up here on the sleeve and the cord across his belt.
So your argument is that they were entitled to the instruction, but that shows that it's not harmful, that it wasn't harmful.
I'm sorry?
Your argument is that it's not harmful, that he didn't get the instruction, or that he shouldn't have gotten the instruction at all?
I'm going to answer your question this way. I don't believe there was a scintilla of evidence at all, so the instruction was not necessary. It was not required. Judge Hur's comment when the defense asked whether she was going to include a lesser included, her statement was, from the state of the evidence, I don't believe it's necessary. I'm summarizing. And basically she said somebody has to ask first, but based upon the evidence, I don't think it's necessary. So she was astute and paying attention. She had years of experience on these kinds of cases, so I know she was tuned into that as well.
But even if we assume that the instruction was warranted, you would argue that it was harmless not giving you?
I'm sorry, the last
Even
part?
if we assume that the instruction was warranted and should have been given, you would still argue that it's harmless?
I do, yes.
The lack of the instruction was harmless, sorry.
I'm sorry?
The lack of the instruction was harmless?
Yes.
Yeah.
Yes. I don't think it was necessary at all. The evidence did not raise anything that would warrant it. I've been reading some of your cases, trying to get a feel for your opinion on this, and I was surprised to learn that the state, from one of your opinions, has basically an automatic right to a lesser included if we ask for it. That might be the opinion, but in some courts, that's not always true. Yes, we do ask for it when the defense has beaten the tar out of our witnesses, and we feel like the state of our evidence has been decreased by that cross-examination, and we need a fallback plan for the jury. So yes, we do ask, but we're not always granted that. So asking by the prosecution does not always mean that we get it. I don't think it's statutorily required, and the judge is going to weigh what he or she believes should or shouldn't be done. So
You didn't ask for it in this case, though?
I did not. I did not. I didn't think it was warranted, and so we stood silent and then told the judge during our part of the response, we didn't think it was warranted. That's really all I have, unless you have some more questions.
Thank you, counsel.
Yes, thank you.
Your Honors, the death of Deputy Kennedy was undoubtedly tragic, but it is particularly in these tragic cases that the safeguards of our criminal legal system must be carefully observed in order to ensure that jury verdicts and sentences are based on reason and evidence rather than passion and emotion. This court has described the purpose of closing argument as to facilitate the jury in properly analyzing the evidence presented at trial so that it may arrive at a just and reasonable conclusion based on the evidence alone and not any fact, not an evidence. The state's...
Counsel, did the judge instruct the jurors that statements by the attorneys are not evidence?
Your Honor, there was no admonishment right after this objection. I have not reviewed the punishment charge to see that, and I can submit a post-submission brief if you would like, but there was no response at that time, and I think that the overruling of the objection with nothing else suggested to the jury that this was not an improper argument at all. But however, the introduction of this inadmissible extra record evidence of the act of others, the invocation of a patron saint of law enforcement and passing that torch onto the jury physically, invoking the other families of other fallen law enforcement officers, arguing that the jury should not let them down by sentencing this defendant to life without parole, and the suggestion that defendants convicted of killing law enforcement officers don't get life without parole. This was thematically powerful, and it was exceedingly improper. In this context, powerful is prejudicial. This court has recognized the impropriety of this sort of argument and reversed cases even with instructions to disregard. In Lopez versus State, as we cite in our briefing, in Escobedo versus State, as we cite in our briefing, and in many other cases. Because this carefully crafted theme played directly to the highly charged through line of this case, the death of a law enforcement officer, and because the jury may have had a reasonable doubt as to the knowledge element at the merits phase, it affected the substantial rights of the appellant. It cannot be disregarded, and the state certainly cannot meet their burden to prove this error harmless beyond a reasonable doubt. For these reasons and the arguments and authorities cited in our briefing, unless there are any further questions.
One more, if you know, how long did the jury deliberate?
I don't know off the top of my head, Your Honor. I apologize.
Thank you.
This argument, was that punishment?
Punishment.
right?
Yes, Your Honor.
You just made a comment that they would have a reasonable doubt as to his guilt. Well, they'd already decided
Well,
guilt. right?
yes, Your Honor, but they were not given the requisite lesser included offense instruction to express that reasonable doubt had they had it. So the precise concern of Beck that a jury might compromise towards conviction was present here.
So are you saying that if a jury might have had a reasonable doubt about the greater offense, then the lesser included offense has to be instructed on?
This court's cases say that if a jury could rationally have convicted on the lesser only. So I think the inverse of that would be that they may have had a reasonable doubt as to the greater. Yes, Your Honor.
So as long as they have a reasonable doubt or could have a reasonable doubt, the defendant's entitled to the LAO instruction.
And there is a scintilla that would support conviction of the lesser, yes.
Well, as long as you prove the greater, you're always going to have evidence of the lesser, right?
Well, right,
So
and the
that's
court,
more than a scintilla.
yeah, well, the court has used the language of lesser only. So if there is evidence on which they could convict, a rational jury could reasonably convict of the lesser only, that would suggest a reasonable doubt as to one of the elements of the greater.
Okay, thank you.
Thank you.
Thank you, counsel.
Thank you.
The case is submitted. Call now cause number PD 046723, Jeffrey Merritt McCUMBER versus the State of Texas.
This is what I hear. Glad we did that.
We'll give our guests a moment to leave. And everyone in the back is welcome to take a seat. Okay, you may proceed.
May it please the court, my name is Emily Johnson-Liu for the state. Permitting the outcry witness to testify over Zoom was proper here. The trial court heard evidence of the witness's intimidation in the form of death threats against her, family medical need to care for her injured husband, and that she had a conflicting court appearance. After that, the trial court stated it would find a necessity shown. Contrary to the Court of Appeals holding, this finding was sufficiently specific, and it was defensible. The denial,
Counsel?
yes.
The lower court, did it, having looked at it, are they only saying that there was a lack of a finding and that's why they reversed? Or are they saying there was a lack of a finding, but also that there was no necessity?
Both things.
Both of these things.
Yes.
If we think that the evidence supports a necessity, do we even care about whether or not there were findings?
I mean, I think that would be enough to reverse the Court of Appeals decision, surely, if you found it a necessity. I think maybe there's some confusion about what is enough to meet that test of being a necessity finding under Craig, so perhaps that it would be helpful, but not necessary. On the first point, though, on whether it's sufficiently specific, Maryland versus Craig and this court's decision in Haggard both say that a case-specific finding is necessary. But what does it mean to be case-specific? I think the Court of Appeals was wrong on this point. In Coy versus Iowa, which is the case immediately before Craig, there was just a legislative presumption that all children in sex abuse cases would need to have this different procedure for protection. And there was no finding in that case that these particular witnesses in front of the court needed that protection.
Well,
So that,
there was more to Coy than that. There was a screen.
certainly,
a
yes.
screen. So
It was a
there
different procedure
yes,
than
yes.
what we're talking about here.
Yes.
But as far as what does case-specific means, in that case, Justice Scalia's opinion said one of the problems there was no individualized findings that these witnesses needed the protection. You just had this legislative presumption. That wasn't enough.
And what did this court say in Gonzalez?
In Gonzalez, this court found situations where that you could overcome the need for
Didn't
full.
find situations as in plural. It found the situation in that particular case supported the use of closed circuit.
That's right. But many other cases since then have found other circumstances of public interest that justify a procedure that's less than full confrontation. So where you don't have face-to-face, you don't have in-person defendant looking at the witness.
Counsel, go ahead.
So someone just saying, I'm afraid, I mean, I would assume a lot of witnesses that testify against a defendant are afraid, and that's enough, or they can't make it that day, is enough to override a defendant's right under the Sixth Amendment?
No, that just saying that you're afraid wouldn't be enough. And I think Romero, this court's decision in that case, supports that principle. But here you had other people acting against the witness, committing a crime of tampering or witness intimidation, retaliation. That is more than just a witness subjective fear on my own without anyone doing anything to me. I'm scared. That's not going to be enough.
What was that evidence?
The evidence was the testimony of witness Crawford. She was the outcry witness,
Okay.
and she testified to things that had happened to her, other people committing 3 burglaries against their house and driving by and making threats against her and her family, death threats.
I want to ask a question kind of in relation to that. Is there any sense in which the trial judge's decision to permit this procedure could have been justified under the doctrine of forfeiture by wrongdoing?
We didn't, because we did not connect it to the defendant.
Was it family or friends of his?
It was family and friends.
You don't
and
think there's an inference potentially there that maybe he's orchestrating things if it's his family and his friends that are
Well, he
engaging in the
certainly
conduct?
benefited from it. But I don't know that we had enough to meet the Giles threshold for forfeiture by wrongdoing. But I make the argument in the brief that it's sort of a comparison. Like forfeiture by wrongdoing allows you to have no confrontation at all, right? You have an out-of-court statement, you have no presence, no oath, no cross-examination. And that is allowed when you have evidence connected to the defendant. Well, maybe this is a situation where, even though we don't have that evidence of sort of estoppel, you created this wrongdoing. You're benefiting from this wrong act. We do have a situation where the witness is still intimidated to that same level, right? That she is so afraid to come to court for that. And so in that situation, it makes sense that one of those 4 protections we have in our confrontation would be not present. Another reason why it seems justified that there's a necessity here.
Counsel, I know that the state asked in the alternative for a continuance. Did the defense oppose a continuance?
The defense wanted the trial to go on forward without the outcry witness, yes.
Okay, so did they affirmatively oppose a continuance?
Well, they didn't say we oppose a continuance. They said, trial judge, you should allow the case to go forward right now without the witness.
Okay, thank you.
Counsel, if the evidence supports a finding of necessity, or actually, if the evidence doesn't support a finding of necessity, but we still don't have specific findings, does that mean the defendant is entitled to a new trial?
If you find there is, that there's no necessity at all
There was no
by the
necessity at
evidence.
all, but there was no specific findings. Is that a basis for reversing the court of, I mean, it's a basis for reversing the Court of Appeals, but is it a basis for a new trial?
If the trial judge was wrong, and we
The
never
trial
should have.
judge is right that there was no necessity, but they also didn't do specific findings.
I think the trial court found necessity.
Yes.
Yeah, that's what I'm saying, but
Sorry.
I guess what I'm trying to get, I'm sorry, I apologize for not making this clear. It seems that deciding whether there is a necessity is a necessary thing in order to affirm the trial court. Right?
Yes.
Right. So it's not just about findings.
It's not.
It's not really going to be just about findings. We still have to determine necessity.
Right.
Okay.
If you find there's a necessity.
There's not an independent, I guess what I'm trying to get is there's not this independent requirement under the Constitution that we should have a specific finding that in and of itself would require the trial judge to be reversed and give the defendant a new trial,
Well, I
regardless
think-
of the necessity.
I mean, I think the defense position is that it requires this, that you
Okay.
don't have the situation where you can allow confrontation or allow the modification of confrontation unless you have that specific finding. That's not our position.
Let me ask a question. If we subtract out the court date that the witness supposedly had and then the care situation with her husband, and we just have the threats, does the effect of the threats ever dissipate? Like, let's say the threats were made 6 weeks after the arrest, but then the trial's not till 3 years later. Like, does the time mitigate the harm of the threat? Like, should there be a temporal requirement that the threats have to be close to the trial?
I mean, I think theoretically there could be, if there's a really lengthy delay, but when you get back to trial again, that's when the intimidation, ratchets back up again. That is the very time when the witness needs protection. So I think even if there has been some dissipation over time, now we're coming back to trial. Now is the moment when you're going to be in the hot seat and you're going to have to decide whether you testify or not. That's
Wasn't
when.
the retaliation when she was in this state and then she moved because of that?
That's right.
Okay, so if they're using retaliation that happened near the actual.
Closer to the event.
Yes. And she moves, yeah, okay, if she has to come back, perhaps she's in fear. But as Justice before brought up, wouldn't that make a difference? I mean, she's removed from that retaliation that occurred.
She's removed from the events that happened, but I think there's still a good, objectively reasonable basis for her to have fear in that moment that the friends and family would again put her in a position where she was at risk if she was returning to Texas. And the trial judge was entitled to make that credibility call. Where you have something, you have a criminal act against the witness, that makes it an objectively reasonable situation for the witness to have real concerns. Even in the Craig case, Justice O'Connor was posing the question, at least an argument, that what do you do about a mob situation? That witness intimidation is a real concern.
Well, why not use closed circuit instead of Zoom? So she's not in the courtroom, but if you use closed circuit, then that would lessen the intimidation factor because she's not actually in the courtroom with the defendant.
I think in this case, it was part of returning to Texas as a whole that caused the concern. Being in
But that was the situation in Haggard too. That witness didn't want to come to Texas.
But the court found those reasons, that, scheduling or, inconvenience to the witness, certainly not enough to justify, an infringement on confrontation.
But if you use closed circuit, you would accomplish removing her from the courtroom to be intimidated by the family or the defendant himself, plus ensuring that the right to confrontation was still there for the defendant.
I'm not sure what more will be gained in terms of confrontation by having closed circuit as opposed to Zoom.
Let me ask you this. Was the problem that she would be intimidated on the stand, or that she would be subjected to more criminal acts?
That she would be subjected to more criminal acts. Within coming back closer to where the defendant's friends and family are, she would be subjected to more acts of intimidation against her.
And she had at least 2 more reasons.
That's correct.
Her husband had broken his back,
That's right.
and she needed to take care of him, and she also had a court date in Colorado or wherever she was.
Right. And so you had this sort of totality the judge could consider in making that call.
And counsel, didn't she go to great lengths to try to hide where she was or where she went?
Yes, that's why the state had trouble finding her in the first place, to get her to trial.
So if there was a dissipation in criminal acts against her, it was because she'd left, or at least theoretically it was because she'd left.
It could have been, yes. And yeah, again, trial judge seemed to be reasonable in making that call. It's something that this court could rely on. As far as diligence goes, that's not always going to be a factor. Again, where the state acting more diligently is not going to affect the witness's ability to confront the defendant any further. It shouldn't make a difference. Factually, it wouldn't have here. Perhaps if the reason for the witness not being present was only short-lived, then diligence could come in. But I think that's more of a factor of estoppel principles, like if the state created its own exigency. Unless there's any other questions, I've reserved some time.
Thank you, counsel.
Good morning. My name is Steve Greene. I was appointed to represent Mr. McCUMBER. I need to start off by admitting I have an error in my brief. When I first did the initial brief before the Court of Appeals, I misread the clerk's record regarding the number of previous trial settings. There was only one previous trial setting. I realized it yesterday when I was preparing for today.
Thank you.
Next, first I would like to say that as I read the cases of Haggard and the other cases that were cited by Haggard, the case-specific findings are required.
Counsel, was there an objection to the lack of case-specific finding?
The trial counsel, his objection was Haggard. Haggard specifically says the case findings are required.
So he objected that the findings were not, I mean, there was a finding of necessity, it just wasn't specific. Was there an objection to lack of specificity in finding?
Not in those words, but I submit that the trial judge was given the Haggard opinion.
Mm-hmm.
The Haggard opinion specifically says case-specific findings are required. Not only did the defense counsel cite some of the factors that were mentioned in Haggard, the state even tried to clue the judge in that the case-specific findings were required. If the trial judge isn't going to listen to y'all, I don't think he's going to listen to a solo practitioner who's already brought up Haggard and what Haggard requires. And it's clearly in the opinion that case-specific findings are required, and the state pointed that out in the argument on the preliminary hearing. The main reason one of the main reasons I submit that case-specific findings are required is because it's my position that the circumstances of the witness should not be the only factors to be considered. And this court in Haggard did also consider the state's lack of diligence in Haggard, and I submit the same problem is in this case, even though there were not two trial settings before the final trial setting, there was one trial setting that was in February, it was set for trial in March, and I know the clerk's record is not specific that both sides announced ready, but there was no motion for continuance filed by either side. So I think it could be presumed both sides were ready for trial in March. We're talking 3 months before the case finally went to trial. And no attempt to contact the witness was made until a week before trial. And this is after the case was finally set for trial, April 20th. The state didn't issue their subpoena applications till a week later, so you've wasted 7 days there. They get their subpoenas on the 28th, another wasted day. They don't give the subpoenas to the investigator till May the 2nd. That's 4 more days, well, 3 or 4 more days. You're talking about 12 days they wasted, not doing anything to try to locate any of the witnesses for that matter. But, I mean, this is a situation where, especially if you have or have announced ready for trial on a previous occasion, I think it's, sure, you may not be the number one case. I know it was a rare circumstance when I was prosecuting that I knew exactly what case I was going to be handling. It takes a phone call to find out if the witness is still around. I mean, if you get a disconnect message on the phone call, you know you got a problem. You need to do some further searching for the witness.
Let me ask a question. If the threats are substantial, or whatever word you want to use for, we're sure that they were threats, does the diligence even matter?
Oh, yeah, I believe so, because, first of all, well, I dispute that the threats were legitimate, or that her fear was legitimate. The reason I dispute that is because here she not only claims that she was afraid of McCUMBER and his family and friends, she says she don't even trust the state to get her to and from court. It would have been a simple, they put her on a plane, she gets on the plane, flies to Houston, DA's office picks her up in Houston, takes her to Polk County. She does her testimony, they take her back to the airport, she's back on the plane to Colorado. There's no way anybody can hurt her. And also, her allegations were not supported by any complaints that she ever made to law enforcement about these supposed threats or about these supposed burglaries that were somehow connected to McCUMBER. I submit that if you're going to believe someone's been threatened, there should be some corroboration of those threats, especially when the witness is saying, not only am I afraid of him, I don't even trust the state. I'm afraid of the state. It doesn't make sense. But if you're truly afraid, you don't just volunteer your full address when you're asked your location. Right off the bat, when she's questioned, where's your location? She didn't say Colorado or Pagosa Springs, Colorado. She said 543, whatever the address was, in Pagosa Springs, Colorado. If you're really afraid of somebody, and that's why you left Texas, they can get in their car and drive to Colorado and hurt you or kill you.
Counsel, are we allowed to look at this record and try and second guess a trial court's determination about whether this person was really afraid?
I'm sorry, I missed.
You're saying, like, you're giving examples of why it is she shouldn't be believed that she was afraid, but the trial court found that there was a necessity. Shouldn't we end up deferring to the trial court on whatever factual determinations that were made?
Not when the trial court even didn't think Taggart applied to this case.
Well, it did make a finding. It just didn't make one specific enough for you.
Well, and that's true. I mean,
Right.
but that's the whole point. Whole reason for case-specific findings is because not only should there be findings as to the circumstances of the witness, there should be findings regarding the state's diligence or lack thereof.
Right.
I mean, they created the emergency by not locating her earlier. They didn't find her until the day after jury selection. And I believe a question was asked earlier about the continuance. The jury had already been sworn, so jeopardy had attached. Now, you have continuances and you have continuances. I mean, if they reset the case for another week for the state to have gotten her to Polk County, well, you may still have problems with the current jury that you have. But if they're talking about trying to get a totally new jury, jeopardy had already attached. They were going to be out, you know, they were going to be poured out of court if they had done that. But also, I submit in my brief also that besides the state's diligence or lack thereof, that we're talking about the trial courts have control over their proceedings that occur in their court. This is taking away that control because, and I know there was one previous trial setting, there are any number of times that you have cases that get reset and reset and reset for trial because of the volume of cases. But if you don't require some diligence on the prosecutor, you're basically leaving it to the party, to the state, to say, well, I'm just going to wait till the last minute to find these people.
I guess one of the things I would ask you though is what are the parameters that we should be utilizing to try to determine when and diligence is enough? Because there's some evidence of looking. You're arguing it's not enough, but the state is arguing there was an effort that was made to look for the person. They did their best. So what are the parameters that we should be using to determine whether there's due diligence or the state exercised due diligence to find the person?
Well, it's like I said earlier, if you have a case, if you have a situation where a case has been set multiple times, okay, the first announcement of ready, sure, they don't know everybody is available at that time, but once you announce ready for a case for trial, it takes a phone call. You know, your witness statements are going to have contact information for the witnesses. Make a phone call.
How does the defendant's right to confrontation fit in with the parameters that we're looking at overall for this case?
Well, a person who is not in the courtroom to testify is not under the same tension, or if you want to call it stress or whatever, that the average witness is under when they are actually in the courtroom. There is some tension when a person testifies in court. When they are 700 miles away, or 800 miles, whatever it is in Colorado, and I know Ms. Crawford did not exhibit this characteristic, but her husband was in the background making all kind of comments, calling the defense counsel an idiot, you know, making all kind of.
But counsel, that was not for the trial purposes, right? Because she was instructed to go to a government office
Right.
for the actual testimony at trial.
Right. What I'm saying is that if it had been the husband instead of her as a witness, and this could be any witness in any case who exhibits characteristics, we've all had witnesses who just won't stop talking, you know, and when they're 1,000 miles away, you're in a lot worse condition or situation trying to control them than if they're right there in the courtroom. The judge can hold them in contempt.
I see what you're saying, and the point is well taken about having the person in being present there for cross-examination but is that really part of what we're here for? Isn't that sort of the second? Aren't we really only here about the necessity for the person, not necessarily whether the proceedings that they had were adequate in order to ensure that it's really just about whether or not they could utilize the procedure?
Well, yeah, I mean, we're basically here, we're here about the necessity.
Right.
Okay. But like I said, I think part of the necessity finding should be based on whether the state was diligent in locating their witnesses.
Right.
And then after you make that determination, and you also determine if the witness is controllable on the stand, then you consider are the witnesses' fears or situation sufficient to justify infringing on the defendant's Sixth Amendment rights? And in this case, I believe Romero was brought up earlier. Adults are expected to be, I think the term was sterner stuff than children. And also, I submit that for a witness to be justified in their fear, especially in this situation, if she had all these problems with people making threats, if she had all these problems with burglaries, you normally report it to the police so the police can investigate and hopefully catch the people. There was no indication she did any of that. She claims to just, head for Colorado. And it's like I said earlier, if you're really in fear of somebody, you're not going to volunteer your address. I mean, you say, I don't want to give my address, I'm not going to give my address. You just don't blurt it out.
So are you inferring that her fear coming to trial, coming back to Texas, was based on speculation as to what would happen in Texas?
I think it's just a way out. She don't want to, I submit, people don't want to travel hundreds of miles. Well, they don't want to go to court if they're in the county where the trial's taking place. But if they're 1,000 miles away, they sure don't want to make that trip, especially when she claims to not even trust the state. There's no reason for her not to trust the state. Nobody from the DA's office was going to harm her or let her out of their sight.
But did she, whether she had proof that she was being intimidated or threatened or burglarized or whatever when she was in Texas and she moves to Colorado, was there testimony from her or somebody else that she was also intimidated or in fear when she returned to Texas to testify?
Well,
Or is it all based on what happened before she left the state?
I believe only her testimony on that was that she didn't trust the state to get her to and from. I believe that's all she said on that issue about getting to and from court. Now, the issue with her husband's back, this is another situation where diligence comes in. If the state had found out where she was weeks, if not a month or so earlier, they could have made arrangements. They could have had a home health care worker, they were going to pay for her to fly to and from Colorado to testify. They could have forked over a couple of $100 more to hire a health care worker, if necessary, to watch him for a day or two that she's in trial. And then her court case was a 10-year-old case by her testimony. I mean, it's 10 years, been pending 10 years, a few days more. The state had already made arrangements for her to testify in a remote room or, a room at the courthouse, apparently. The state, I submit, could have made arrangements to reset her case for a few days when you consider it was 10 years old already. But the fact that the state was not diligent getting, locating her, complicated all that because it's obviously easier to do that kind of thing when you have a few weeks notice as opposed to a day or two notice. If you don't have any other questions, I'll give you back.
I would like to ask one more question, what's the appropriate remedy if we find that the trial court's findings were insufficiently specific to the facts of this case?
To affirm the judgment of the Court of Appeals and revert and send it back to the trial court for a new trial.
Okay. You don't think that there's some way that we might ask the trial court to, after the fact, make findings? We do that kind of thing sometimes when, for example, in competency cases, trial judges can go back and make a sort of post-trial determination of competency at the time of trial. Is something like that
Motion to suppress.
possible? Would it work? Is there reasons why it wouldn't work?
Well, it's my position that y'all have the facts before you. I mean, yes, you can do that, obviously, but it's just creating another delay in the litigation. I mean, I think about 25% of the trial record was devoted to the hearing on whether she was going to be allowed to testify by way of Zoom. And I submit that the findings could be made by this court rather than waste more time and resources sending it back to the trial court.
Thank you, counsel.
Thank you.
This is not a situation where we should be overly concerned that every witness is going to claim the kind of fear that the witness was here. You can require an objectively reasonable set of circumstances. You can require acts of criminal conduct against the witness and evidence that the trial judge believes. But that's ultimately where you begin to construct this necessity, is what did the trial court, what evidence was there and what could the trial court have believed? It's trial court's prerogative to decide these questions, and when the witness was asked, do you have any illness or other ailments that would prevent you from returning to Texas? And she said, nothing other than the fear of death. Seems to indicate that she's worried about coming back to Texas because of the intimidation that these criminal acts that have been perpetrated against her. And if that is not what happened, it's really incumbent upon the defense to ask for those additional findings from the trial court.
Counsel?
Yes.
I'm glad you mentioned that. So if there's a lack of objection to more specific findings, why don't we just look at the evidence in the light most favorable to the trial court's ultimate finding?
We do that,
Right.
yes.
Yeah, I mean, like we do that in Cullen, we could do that in, like, any motion to suppress. If they don't ask for specific findings, we just sort of look at the record in the light most favorable to whatever the trial court ruled.
That's right. And here that would mean that trial judge credited all of her concerns, and that this was not just speculation, that she had a real basis for having fear of returning to Texas. And that, staying in Colorado, moving to Colorado in the first place, gave her that protection. She was able to testify while still in Colorado without having to be subjected to whatever additional conduct might happen against her. It really was incumbent upon the defendant to ask. He didn't. Therefore, the usual state law presumptions apply. We don't have a constitutional right to these subsidiary factual findings. And certainly where he doesn't ask for any, then we're left with the usual appellate presumptions.
Can we consider that there was an alternative available to the state, like I spoke of before, like closed circuit, to accomplish both things? Taking care of her fear to testify in front of the defendant and upholding his Sixth Amendment right? Can we consider that there was an alternative to this?
It wouldn't be determinative. I mean, consider it, but Craig especially says that there does not have to be a consideration of alternatives like there is in the Waller v. Georgia context. So there you have other protections other than just the two parties to be concerned with. So perhaps there's greater reason to consider alternatives. But Justice O'Connor's opinion says you don't have to do that.
When the Supreme Court says, so the Supreme Court has addressed this situation in the context of a Sixth Amendment argument, right? Somebody's preserved a Sixth Amendment claim. And they say that these specific findings are required. Are we at liberty to say, yeah, the Supreme Court has said they're required, but if somebody doesn't object to the lack of those findings, you see what I'm saying? Do they have to preserve the Sixth Amendment claim and the absence of the findings when the Supreme Court said you have to make the findings? You know what I'm saying? I'm trying to
I think
figure that out.
Yeah, when a defense attorney objects under Craig, says confrontation, they have preserved the right to get a finding of denial of face-to-face confrontation is necessary for important public interests. They are entitled to that. Okay, but that was the finding here when trial judge says that is, I'll make a finding of necessity here. Implicit in all of that, just like there is in Lively, that this is what the trial judge was deciding. The parties all pitched this. You know, you got to consider Haggard. It has to be case specific. The defense attorney talked about there has to be important public interests. Trial judge knew that was what was being decided and made the express finding, I find necessity here.
But here's my overriding, right? I'm thinking sort of past that and only academically, okay? In the sense that if the court finds that finding that the trial court made isn't sufficient under the U.S. Supreme Court's view, are we at liberty to say, yeah, but nobody objected, so to the lack of more specific findings, so they waived that? Are we allowed to do that, or are we stuck with, if there was no findings, got to reverse?
Well, you could abate for findings. I think that would be the more limited, tailored to the violation. If it's not specific enough, send it back to get that specificity. But I think if indeed it's constitutionally required that you have some sort of finding, I don't think Texas law could trump that. What I'm saying is that these are the sort of elements that make up the broader finding of it is necessary to invoke or to inhibit some of his confrontation rights. That's necessary. The elements that make up that claim don't have to be expressly set. And if you need the fact findings that would determine all of these subset elements, then ask for those. That is what's going to be controlled by state law. Craig requires that finding that a denial is necessary.
So if we're supposed to look at the cases, each case on its own, but we decide, let's say we decide to go with your approach that this general necessity finding is sufficient, then how is that going to work in the future as far as case specific? Because from now on then, anybody just says, I find necessity is enough. That's not necessarily case specific. That's pretty broad.
Okay, so you still are going to have to look at the context of that case, right? If there's no hearing, there's no evidence, and the trial judge certainly, if the parties are not talking about what's required in this necessity finding. But once the parties talk about this and the trial judge then shorthands to, I'll find the necessity shown, then that pulls back everything that's happened before then. So I think, and that's I think what Lively is talking about. That was another case, and I see I'm out of time.
Finish your-
So in Lively, it was about videotaped child testimony, and the trial judge did not make a specific finding that it was the presence of the defendant as opposed to in the courtroom that required this different procedure. And this court held that just saying that it was the psychological needs of the child warranted the procedure. You didn't have to do all those elemental findings of each.
And let me just, I know Zoom, closed circuit's been around for years, but the Zoom is relatively new. Are there any other cases outside of Texas that have had to deal with this issue of using a Zoom process for a witness? Because they're clearly different. And in my mind, they're different as it relates to confrontation. And has anybody else used it, as far as you know?
I do believe there are other cases. I'm not sure they are using Zoom as opposed to other technologies, but the federal courts have used telephone conversations, in addition to closed circuit. So I'll have to research this a little bit more to tell you.
Okay.
Thank you.
Thank you, counsel. The case is submitted.
All rise.
Oyez, oyez, oyez. The Honorable Court of Criminal Appeals now stands recessed, subject to the call of the presiding judge.